you so much for joining us today. My name is Michelle Dexter, and I am with Keystone Law Firm. I'm an attorney here, and I handle our estate planning as well as our informal probates, our trust administration, and our guardianship and conservatorship matters. We appreciate you guys being here today. Alexis, I just want to confirm that you are recording today's webinar so that we can have this for future people. Thank you so much for confirming that. Today's topic is what not to do and some of the horror stories from probate. My son, for those of you who don't know me, my son plays football. And so for me, the scariest person on the field is the ref. And one of my son's refs, so I was lucky enough to even get the yellow flag. So we like to have some fun with stuff here at Keystone. They're very serious topics and they're tough to deal with, but having people that can help guide you through this and know what things we're looking to avoid can really be helpful. And so we encourage everybody to get their estate planning in place and regularly check in on those documents, because otherwise you end up as one of our horror stories from probate. All right. So I'm going to go ahead and get started. One of the biggest issues that we tend to have is people thinking their estate is so simple that they really don't need estate planning. You have to understand the definition of simple here in estate planning. Okay, simple is generally everything to spouse and everything to your children outright. If you have a spouse who's incapacitated, if you have children who are not poor at handling their money, if you have, certain dynamics within your family that aren't conducive to just making everything simple, then your estate's not simple. And oftentimes I find myself explaining to people what their options are when it comes to the different things that they can do based off of their specific family needs. And it's really important to know those things. For those of you who maybe don't have a spouse or don't have a child, people without significant family ties can often have issues with who their estate is going to pass to. At the end of the day, we really don't want the state deciding who that's going to go to. That can lead to lengthy court action, misinformation, and your assets being directed to the state. We had a matter a couple of years ago. A lady was notified that she was the beneficiary of a piece of property, and that an investor was interested in purchasing this property. So the investor had traced the family tree from the owner of the property to this lucky lady who they determined was the beneficiary. She went through all the steps. She opened probate, she sold the property, she collected the assets, she distributed to herself with the belief that she was the only beneficiary. And after she had used all that money to remodel her house, she learned that, in fact, she was not the beneficiary. That investor had missed a step in tracing the family tree. And she had to now give all of the money that she had received to the true beneficiaries. So you can imagine how distraught and upset she was about that situation. That could have easily have been avoided if the person had had an estate plan in place naming who their beneficiaries were going to be. In addition, you're going to want to make sure when you have no spouse or children to review your designations regularly. If you've named charities that are local, you're going to want to make sure they're still in existence. As a lot of times churches can change names. In our documents, a lot of times when we're naming charities, we'll say this charity first. If they're not still there, their successor in interest. And if they don't have any successors in interest, then we're allowing your trustee to name a charity with similar purposes. And that just kind of is our plan A is the charity, our plan B is their successor, and our worst case scenario is the trustees naming somebody so it doesn't have to go to court and it doesn't end up in limbo, okay? So you can definitely include language that authorizes your trustee to choose a successor charity or to, just direct where those funds are going to be so that we don't end up being caught without an existing charity, okay? A lot of times when people think that their estate's simple because it's just going all to their children, they don't necessarily fully recognize the issues that their children may have, that their children aren't managing their relationships or their finances well. And we want to prepare for our children so that they can extend the money until they're at an age when their brains are fully developed and the concept of money is a little bit more solid. So if we've got really young kids, we're setting up a trust so that they're not having direct access to it until they're a little bit older. If we have older kids, we might be trying to preserve some of it for their retirement or make their lifestyle better. We had a case about 2 years ago. Mom died. She had 2 college-age sons and no estate plan in place. The sons came in with their uncle, and one was appointed as the personal representative. Their uncle fronted the money to get the case started, and with the expectation of being paid back. Once the house was sold and the accounts were liquidated, though, no one could get a hold of the sons. Turns out he'd been lying to his grandma about going to college. She'd been paying his college tuition, although he wasn't actually attending college. And so, to find out all of this information after the fact, the uncle was never reimbursed. The family relationships with those boys was destroyed. And I'm really not sure how long that money is going to last them. But it seems like had the mom set up an estate plan and maybe been recognizing what was happening with her kids, she could have prevented this money from just being wasted with them. And so it's certainly scary. I have 3 boys myself. The oldest one is 22 now. But when I look at their ability or their lack of ability, they've never really managed a significant amount of money themselves yet. And so sometimes we have to be honest with ourselves in terms of, yes, my estate would be simple. It would be all to my husband and then to my 3 children. But my 3 children are not in a position yet where I would want them to have the amount of money that they're going to be inheriting from me at this point, just outright to do whatever they want to. I often worry about kids that will receive a certain amount of money in their 20s and think, I'm never going to have to work again in my life. And they either don't get their education or they don't get their career started. And a lot of times those, first 5 to 10 years of your career, not only are you building your career to get to higher levels later on, but you're also adding to your retirement accounts and you're building for your future. So it's really important that we're setting up our kids for success and being honest with their abilities with regards to that. We also see issues where a child is named as a beneficiary and that child's now receiving government benefits, and they'll be disqualified from those benefits if they receive the inheritance. So this can put that child in a really difficult situation. And it's important that you understand, the financial situations that your beneficiaries are in. I know a lot of times, children and parents often think, what the other is doing is their private information. They're not having those tough financial conversations with their kids or with their parents. But it is important to understand that if they're receiving some government benefits and those government benefits are based off of what they have in terms of assets, sometimes it's called a means-based government benefits, they can be disqualified from those benefits as a result of inheriting from you. And what they're going to have to do is they're going to have to spend down those funds in order to re-qualify for the benefits. And for those of you who have ever tried to qualify for some of these benefits, it can take months, if not longer, to get qualified. And so we really want to make sure that we're not setting them up for a position where the money's hurting them more than it's helping them. The kids can't disclaim their interest in those in that inheritance when they're receiving government benefits, because from the government standpoint, if you have other money available, you should be using that other money, right? And so a lot of times the families are upset that their sibling is going to lose their benefits, that this money is going to be spent down, where had the parents just been honest about it, they maybe could have redirected it to the other siblings and helped with the quality of life, or set it up for the child who is receiving benefits in a special way that wouldn't disqualify them from their benefits. Okay. We had a situation last year. Dad had not updated his will. He had one son. His son had died. His son had produced a son. So he had one grandchild, but the will was so old. It was before the grandchild was born. It was before the son died, that the will did not provide for anything past the son. And so we had to go to court with the copy of the will and explain and verify that the grandson was actually related to the decedent. In addition, the personal representatives that this gentleman had named in his will were all deceased as well. So now the mother of the grandson was petitioning the court to be personal representative to confirm that her son was the beneficiary. And his family, his in-laws and things like that were a little upset that this, lady was going to come in and take control and that the grandchild was going to take everything. Had he updated his documents, he probably still would have named the grandchild as the beneficiary, but maybe he would have named somebody else to oversee some of those funds for him. And so it was a really contentious situation there for a while for something that really didn't need to be had he just updated his documentation. Okay. The other issue that we run into when people think their estate is simple is they have kids that don't get along with each other. When you've got kids that don't get along with each other, despite the trustees or the personal representative's fiduciary duty to all beneficiaries, it can still be a point of contention. Okay. I had a case shortly after I started here. Mom had a very detailed estate plan. She had a trust, a family limited partnership. She had her beneficiary designations. There were still a couple of assets that fell outside of all of those things and required probate. So she was a very complex case. She had 2 daughters. She had named them to act together and everything. She was also part of a blended family and her husband had passed away, but she had some stepchildren named as beneficiaries for some of the things. She named her 2 daughters to be co-everything, co-personal representatives, co-trustees, co-partners in the limited family partnership. But at the time Mom died, one daughter had a restraining order against the other daughter. And so the 2 of them refused to work together. They refused to work apart. They refused to split up tasks. And they also refused to agree on a third party. Mom had died in May of 2018, and it was September of 2019, almost a year and a half before the parties, with the help of a third party fiduciary, were able to reach an agreement resolving the outstanding issues. And it was 2021 before all of the issues were finally resolved. That was one of the things that when we've got siblings that are that contentious with each other, we may look at, let's name a neutral third party that can just handle it so that neither one of them has the power or authority over the other one. And we're reducing some of those issues, because while it seems like the neutral third party may cost more, the amount of money that these 2 ladies spent between their own attorneys and the court hearings that they had, and at the end of the day, they ended up paying a third party anyway to do it. So it's hard to admit sometimes that our kids don't get along, or maybe they aren't the right people for this position to handle these financial responsibilities or the healthcare responsibilities. But you have to be really honest with yourself and with each other with regards to whether or not they're the right people to handle those things. Okay. Now, I mentioned earlier that my son plays football, so sometimes some of my references are a little more sports directed. Some people think that their estate plan is simple because they don't have that many people that they're choosing from. I call that a small depth chart. In football, you've got your starters, you've got your backups, and then you've got your 3rd and 4th string type of people, right? Having an estate plan that is robust with several layers can really be beneficial, right? I always work in worst case scenarios, right? I want to make sure that I've got my plan A, my plan B, and my worst case scenario. So in a lot of situations, your kids are the plan A, your grandkids might be the plan B, and that's usually fine. But if you only have 1 kid and 1 grandkid, you really need to think about who your worst case scenario is going to be, okay? If you don't have something, so our standard remote contingent distribution that says I don't have any kids or grandkids, or my initial beneficiaries that I've named are not there to receive it. We have a remote contingent distribution provision that says if I don't have any of my named beneficiaries, then it should go pursuant to the intestate laws so that it doesn't just go to the state of Arizona, right? You can name a charity, you can name a specific other person, you can name lots of other options when it comes to that remote contingent distribution in that worst case scenario, but you definitely want to give it some thought. If you don't give it any thought, the intestate world is basically If your parents are still alive, if you don't have children or grandchildren and your parents are still alive, it's going to go up to your parents. If one of your parents is still alive and they inherit that from you, and then their estate plan says it goes equally to your siblings, and maybe you don't have a sibling that you're very close to or that you don't want those funds to go to, you may have inadvertently distributed someplace that you didn't want to go, right? So reviewing that, knowing how that works, and naming the charity or the friend or the loved one that you really want to receive would be great. Sometimes we have beneficiaries who are surprised that they're the beneficiaries and believe that it really wasn't the intended result of the person who died and left them the money. And a lot of that can be simply that they didn't realize how that was going to go, and they didn't plan for that worst case scenario. Okay. Another situation that we have when people think their estate is simple is using inexpensive legal forms. Okay. I get it. Coming to an attorney can feel like it's an expense. It can feel like it's time consuming. It feels definitely like there are easier ways to do those things. And I get that. But oftentimes those attempts to save money create additional legal litigation after you're gone. Okay. In 2021, we had 3 different litigation matters where the decedents had all used the fill in the blank forms that they purchased at a local shipping store. Okay. The ambiguities that were created in those wills, because they were completing them themselves and thinking that they were a simple fill in the blank, created some ambiguities that required judicial interpretation. And each of those cost thousands of dollars in additional expenses to have the court clarify what they thought the decedent meant by it. Okay. So you really want to be careful about using some of those forms, because there is way too easy of a way to make that more complicated than you're intending. Okay. The other thing that people will do is what we call holographic wills, right? You've probably all heard, if you have something in your handwriting that you've signed directing where your assets are going to go, the court will accept that, right? So first of all, one thing I want to remind everybody of is that a will is just directions to the court for probate. Okay. So a will is not avoiding probate like a trust is avoiding probate court. A will is saying, hey, when we go to court, this is what I want to tell the judge. Okay. So that becomes public record. That can be a lengthy process. There's a lot of notices and public notices that go out as a result of that. And so here at Keystone, right, a lot of times we're trying to avoid probate, but I understand people are like, this is simple. I don't need all this fancy trust stuff. But the truth is there's a lot of good reasons for having the trust, not only to avoid probate court after you die, but also if you become incapacitated, it's a stronger document than your financial power of attorney. And I'll talk a little bit about that. But going back to the holographic wills, okay, so you can handwrite directions to the court, you sign it, and you can indicate where you want your assets to go, right? There are specific requirements in order to qualify as a holographic will. But people are trying so hard in those situations to keep that document simple. They're missing key elements, okay? They need to identify who are they naming to be the personal representative? Is a bond going to be required? Is there a contingency plan in the event that their beneficiary is not there or unable to receive their funds? And failing to include these provisions ends up requiring a court hearing to answer those questions by the judge and to determine how is this probate moving forward, because the information that you're receiving in that holographic handwritten will isn't enough to cover all of those things. And a lot of times when you're looking at the statute about a holographic will, it's very basic, right? In your handwriting, directing who your assets are going to go to. But there's a lot of key things that kind of get missed in those holographic wills and end up having to go before a judge to get answers to that information. Okay. My next series of things is you need to know how the law works, right? Ignoring how the law works can really create issues on the backside that you're not intending, right? So do you know how your assets will be distributed if you don't have a will or trust and you're not directing where that is going to go? And if you know, is that what you intend, right? Do you have siblings that you prefer not to receive your assets? Are your parents going to receive your assets and then it's going to trickle down to those siblings you're trying to avoid? You want to make sure that you are being direct about that, okay? In addition, one of the bigger things that I see is blended families, okay? So if you are in your second marriage or a subsequent marriage and you have children from a prior relationship, we consider that to be a blended family, okay? Many people think, I'm married, my spouse has priority. But here in Arizona, at least, when you have a blended family and a person dies without a will, your spouse will not be receiving everything, because the way that the laws work here in Arizona for intestate situations where you've got children from a prior relationship is that your spouse gets their half of the community property and one half of your separate property, and your children get your half of the community property and one half of your separate property. Okay. That generally is not what most married couples intend. Okay, we've had more than one spouse that's come to our office to learn that they don't own the house outright and they have to move out or pay one half of the value to their stepchildren because there wasn't a right of survivorship. It wasn't directed all to them through a will or a trust. And you can imagine how devastating that is to learn that you've lost your spouse and now you maybe are being forced out of your home because of children that maybe you don't have the best relationship with, okay? You also need to be aware that even in a community property state, people can have separate property, right? Things that you bring into the marriage, things that you inherit during your marriage can be considered separate property. And so things that it doesn't always require a prenuptial or postnuptial agreement to maintain that separate property. But if you have separate property and you have specific plans for those assets, you want to make sure that you're getting that in writing. Okay. I have occasionally clients that are inheriting something from their parents, and they want to make sure that when they die, those assets go directly to their kids. They're not really intended for their spouse because it's more of a family line type of thing. And so if those are things that you're wanting to make sure are going to happen, you want to make sure that you have that in writing. And so knowing things about how the intestate laws work, how it works with blended families, how it works with separate property. It's important to know all of those things, how it works for your family, how it works with your assets, and how you guys are setting those things up, okay? You also want to be sure that you're being honest about your situation, okay? Surprise children. And this may sound like something that you wouldn't really expect, right? But make sure that you are addressing all of your children, including deceased children, in your estate plan documents, okay? We recently had a wife whose husband died. She knew he had 5 children in a prior relationship, and they had 2 children together. So he had 7 children altogether that she knew of. After he died, she learned he was having a relationship and he had a girlfriend, and that they had 3 children together. This is not the type of news she wanted to receive when she was grieving his death. And suddenly we had to change all of the documentation to provide for 10 beneficiaries instead of 7 beneficiaries. I also was doing an estate plan where mom was leaving everything to one child. It was the only child she mentioned to me. Before we sign legal documents, sit down with my clients and I go detail through all of the documents they're going to be signing. And when I got to the family information, I was like, and this is your one child. And she said, actually, I have 9 children. And I was like, what? And I was like, why didn't you mention that? And she was like, well, they're not receiving anything. Do I have to mention it? And I was like, yes, we have to list all 9 of them, because one, all 9 of them should be getting notice when the time is appropriate. But also when we're coming to validifying that you have capacity at the time that you're signing documents, right? If I say I had conversations with this woman and she seemed to have capacity to me, and her 8 children come in and say, but she didn't mention 8 of us. How did that get overlooked? You have to ask, did she, like, why was she not mentioning them? So it's really important that you list and give full disclosure of everything that you have going on in your life, that's going on in your kid's life, that's going on with any of your beneficiaries. The best way that we can help you to have really solid documentation in place is to know everything that's happening with your family, with your assets, with everything. So you want to make sure that you're doing that, okay? You want to make sure that you're not ignoring your documents. I know it feels really good that you have completed getting documentation in place, but you want to make sure that you are reviewing the documentation on a regular basis and that you're not ignoring the property distributions that you are doing during your lifetime, okay? So if you are taking care of any property distributions during your lifetime, you want to make sure that your documents are either reflecting that or reflecting that that property distribution has already been done, okay? You also want to make sure that if you inherit something or if you've got a spouse that passes away, that you are taking care of those property distributions during your lifetime, okay? We often see where spouses have rights of survivorship, one passes away, the other one doesn't do anything with it, and then the kids are having to address both of them, right? Recently, even this week, in fact, I had a client that came in that a stack of savings bonds. Some of them were in their mother's name who just passed away, but another stack of them was in the name of their father who passed away years ago and their grandmother who passed even before that. So now, in addition to taking care of mom's stuff, we're having to do separate actions for dad and grandma. We had one case a few years ago that great grandma owned the real estate. After she died, her child moved in, then her grandchild moved in, and currently her great grandchild is living at the property. None of them had ever updated the title to the property, okay? So the great grandchild who's currently living there has been paying expenses. She wants to remodel the property. She wants to get a loan against the property and put it into her name so she can do what she wants to with it, right? Unfortunately, because it hadn't been properly passed along, as part of the probate process, we were going to have to notify all of the relatives. When she put together the list, she approximated, because she's not even in touch with all these people, she approximated that there's probably 70 people that could all be interested in a portion of the property. Okay. Now, had that child taken care of the property distribution at the time that the great grandmother had passed away, there maybe were a smaller amount of siblings, and maybe all of them would have signed off on the one child keeping the property, right? Or maybe they could have addressed how they were going to offset the property and let that one child keep it. By going so many generations, we've just multiplied the number of people that all have an interest in it. And the chances of getting 70 people to all disclaim their interest and say that this grandchild can live in it is pretty tough odds. She's come to us several times wanting to do it, but every time you're going to have to identify all 70 people. We're going to have court hearings. We may have to do private investigators to locate all 70 people. And it just gets to be so overwhelming for her that she takes a step back, and then she'll come and then she'll take a step back. And so it's not getting any better. But at some point in time, something's going to have to happen with that property so that it can be in the name of a current owner. Okay. We also have situations like that where property in a divorce is not properly addressed. So, you get divorced, one person is to receive the property, and maybe they haven't signed the deed transferring that property back. Maybe they did a deed, but the deed actually wasn't effective. And so we've had a lot of cases recently where we're having to go back and find that ex-spouse and have them sign some new document. We have one case where ex-spouse did a deed. They didn't do it correctly. They remained as a right of survivorship on a piece of property. Our decedent passed away. The ex-wife actually filed the death certificate and had the property transferred into her name. And so our client now, their next step is to file something with the court to quiet title on that property to get that transferred out of her name that shouldn't have been put in her name to begin with. And so it's just an additional complication, additional attorney's fees, additional hearings, having to deal with people that have kind of been out of everybody's life that, doesn't always end on a good note anyway. Typically, if somebody's going to take advantage of somebody's death and file the death certificate so that they can get the property, it can be very problematic. And so it just really adds layers to what is already a difficult situation. And we really want to try to avoid some of those different things. So making sure that you're taking care of that stuff during your lifetime so that your future generations don't have to do that is really important. Okay. Another issue that we have, another horror story that we have, is people who have insolvent estates. Okay. Now, an insolvent estate is when you owe more than you have in assets. Okay. So that means that you've got more debt, more taxes, more whatever than you do in terms of what the assets and income for the estate are going to be. In a lot of cases, your beneficiaries may just want to walk away from it altogether and let the creditors fight over whatever assets they can get. In other cases, we've got families that feel that they're obligated to wrap it up. The state of Arizona does have a statute that sets out the priority for creditors, starting with expenses of administration, last illness and burial, followed by taxes. And then finally on the bottom of the list is the unsecured creditors. When a family member or friend is tied to your debt, they may have no choice but to try to resolve it. And so trying to deal with some of that stuff during your lifetime can be very helpful. We had a sister who was storing her brother's trailer at her complex where she lived. She had to be able to sell the trailer to resolve the lease for the trailer space after his death. And because that trailer space was tied to her name, she had to open up probate to be able to sell the lease and address all of the creditors and take care of it. And so it was a really unfortunate situation, but she felt like she didn't have any choice because this was tied to her and she needed to take care of it. Now, I'll tell you, with regards to that trailer, ADOT has a very simple beneficiary designation form that he could have named her as the beneficiary of that trailer. And she could have then sold the trailer, dealt with the parking spot, and it would have resolved a lot of the issues that she had. But because that form wasn't completed, she had to deal with all the creditors as part of it. Okay. Another issue that we have is when people have estranged children. Maybe you initially said all equally to my children, and then suddenly you don't have a relationship with them anymore, but they're still beneficiaries of your estate. This is often very complicated when you have multiple siblings and you've got one that is just kind of MIA. They're not participating with the other siblings, that we don't know where they can be found. And the lack of knowledge about them can really complicate things. Okay. In addition, alternatively, right, when your kids don't know about your assets, your expenses, your information, it can make it really hard on the kids, because if they haven't had a relationship with you, then they don't know, where did you bank at? What types of assets are we talking about? Is it going to be an insolvent estate? Because they just don't know, right? And so to the extent that you've got a situation where maybe you still want to leave something to those kids, or you want them to still be in charge, set up the information so that it's easy for them to learn everything, right? Make a list of where all your assets are. Where are your bank accounts? Do you have retirement accounts? Make it simpler for them, because it can be really difficult to administer your estate without having that information. And they're always afraid they're going to miss something. They're doing extra work trying to find everything. And more money can really be spent with the attorneys questioning and learning and litigating issues that could have been resolved with just clear information about your assets and your wishes being put into an estate plan. Okay. So keeping some of that information. I know even recently I had somebody come in, his father had passed away and he was helping his mom, and he was like, I don't know if they pay SRP or APS. Like, I used to be able to tell clients that everything will come in the mail in about 6 months, but nowadays that isn't necessarily true. So having a list of who your expenses get paid to monthly, who your homeowner's insurance is, what's being paid by automatic deposit, what you're writing checks to, what's being paid by a credit card, those types of pieces of information can just be really helpful to help people know what they're getting into. Okay. When a spouse or child doesn't know how to find your assets or deal with your bills, it's just really problematic. So, a list of your assets, a list of your creditors, a list of your bills, how do they get paid? Who do they get paid to? When do they get paid? Are you paying your homeowner's insurance monthly, quarterly, biannually? Is it getting paid through your mortgage? How's it getting paid, right? We're not receiving those mailed statements. And by the time we do, it's usually, the way past due notice. So we want to make sure that we're not making your agents dig too hard. And if you're the primary person managing the household finances, help your spouse or children out so they can step into that role more easily with leaving them with some basic information. Okay. Also key, don't forget your passwords and access to your computers, your emails, your cryptocurrency, your phones. Those are all very key things. Our calendars are on our phones, our contacts are all on our phones. If we had to notify somebody that you're not going to make it to an appointment tomorrow, we have to be able to access your phones. Apple and Android phones both have a way to set up, Apple calls it a legacy contact. I have to double check on what Android calls it, but a way so that you can leave trusted people to be able to access that information. And so that's really key, but also making sure that they can get into your emails, they can get into your computers, they can do those types of things. And you don't have to set them up where, hey, I'm giving you all of this information today. Keep it in a secured location so that when they need to, you can say to them, I've written down all this information, and when the time's appropriate, then you can access it. I'm not looking to have people access information from you prior to when you actually need them to help, right? Make sure you've got your plan B and ideally your worst case scenario. A lot of times when we've got beneficiary designations on your life insurance, on your retirement account, sometimes people do that on their bank accounts in lieu of having a trust. If one of your beneficiary dies, you need to know how those funds are going to be distributed, okay? Because if there's any ambiguity, that's when the court's going to step in, right? So if you are setting up your retirement account and you've got your primary beneficiary and your contingent beneficiaries, what happens if one of your contingent beneficiary dies? Is there something that says that maybe it's going per stirpes or by representation to their beneficiaries? Do those people have beneficiaries? If I say it's going to my 3 kids right now, none of my children have children of their own. So if one of them passes away, I need to know, is it going back to the other 2? Is it coming back to my probate? Is it going through his probate? Where is that money going so that I can make sure that it's going appropriately to where I want it to go? Things like life insurance, that can easily come into the trust. Retirement accounts are a little bit more difficult because of some of the tax obligations, but we'd be happy to talk to you about some of the options for that when you're looking at that. But when you're filling out those beneficiary forms, think it through. What would happen? It's nice that you've got your primary beneficiary and then your contingent beneficiaries, but what would happen if your contingent beneficiaries were there? And are you updating those documents when one of your beneficiaries passes away? Okay. Our policy is here in the office, we update all of your estate plan every 5 years for our trust care clients, whether we're changing the people in them or not, whether we're changing the beneficiaries, whether we're changing the agents, because we want those documents to be fresh. But you also want to make sure that you're updating your beneficiary designations, okay? We had one situation where a lady named a married couple as her beneficiaries. When they were getting a divorce, she came back in and updated her trust documents to remove the beneficiary of the married couple that she wasn't happy with. However, after she died, we learned that she had named both beneficiaries on some retirement accounts and had not updated those accounts. And they didn't flow through the trust. So they went directly to that other person that she had taken out of her trust. And we know she would have really been disappointed to learn that this person had received anything from her estate. And so you just want to make sure that in addition to updating your estate plans, you're looking at those beneficiary designations and updating those as well. Okay. You should be reviewing your documents annually. We recommend updating them every 2 to 5 years, even if you're not making changes. If you want to make changes, consider consulting a professional. Don't be pressured into creating a new trust document because your document preparer is not authorized to restate your current documents, okay? In one case, we had where husband and wife had created their trust through a local credit union. After wife's death, husband went back to the credit union to update the trust, but they couldn't update the trust. They can only create new trusts. So he created a new trust with them based off of the guidance he was providing. Unfortunately, he failed to update all of the funding of his assets to the new trust. And when he passed away, he had assets in both trust names, okay? Unfortunately, each trust had different beneficiaries with different percentages. They had slightly different trustees. We tried to see if we could get all the beneficiaries to agree to go with the terms of the new trust, but because some of them had a reduced interest in the new trust, they weren't willing to do that. And so it ended up being a lot of additional work for the trustees to manage it, more expense for all of the beneficiaries. And so you just want to make sure that you're doing it correctly when you're doing it. Having multiple trusts is a complicated thing to do, and you have to be really intentional about it and really know what it is that you're doing as part of that. And so when you're doing these types of things, consider whether or not going back to somebody who says we can't restate this, we need to do a new one is really the correct way for you to go. Okay. We also want to make sure that you're funding your trust. Okay. Executing your documents is the first step, but without funding your trust, your family is going to be forced to take additional steps to administer your estate after you're gone. Okay. I tend to think of it as 3 different buckets. I wish I had a third hand. 3 different buckets that your assets will go into. Any assets that remain just in your name during your lifetime will be subject to probate. During your lifetime, they're subject to a power of attorney. And if the financial institutions don't accept that power of attorney, you're looking at a possible conservatorship. Okay, so that's that first bucket, things that are just in your name. The second bucket are things that are in your name with a beneficiary designation. Okay, so that's going to help us avoid probate after you're gone. But again, remember, you got to make sure that you're keeping those beneficiary designations up to date and considering whether those are appropriate beneficiaries, if those beneficiaries have any government benefits or special needs that they shouldn't be receiving that money outright. Assets that are in your name with a beneficiary named on them during your lifetime are going to require a power of attorney. And if they don't accept the power of attorney or you don't have a power of attorney, then that's when we've got that possible conservatorship. Okay. Our third category are trust assets. Those don't require probate. They don't require a power of attorney. And so we're never needing a conservatorship with that. But the key thing is that for those assets to be in that trust bucket is that those assets have to be named in the name of the trust. So your checking account would change from Michelle Dexter's checking account to Michelle Dexter is trustee for Michelle Dexter's trust account. And that's how it would be titled. Okay. So all of your assets that can get titled that way, the better, because then we don't have the opportunity for the bank to reject the power of attorney and force a conservatorship. So not funding your trust means the assets could potentially go through probate to get to the trust. So, you know, in our estate plans, we have the trust document, we have the pour over will. The pour over will is our contingency plan, but we got to make sure that we're putting as much into the trust as we possibly can. Recently, the Arizona legislature increased the amount that requires a court probate. We have what we call a small estate affidavit system here in Arizona. And so personal property, the limit used to be $75,000. It's now $200,000 that you can have in your name without having to go to court. You have to fill out a special form to do that. The real estate, small estate affidavit procedure, it still gets filed with court. They've increased that limit from $100,000 up to $300,000. I think for a lot of us, property value wise, that probably doesn't help as much as we would like. But, you know, if you have a mortgage on your house and your house is in your name, you can put the beneficiary deed so that it avoids probate there. And we run into a little bit less problem with the power of attorney with realtors. It's the financial institutions that we get really nervous about that power of attorney and the risk of having to have a conservator in place. Okay. Don't forget to plan for incapacity. Okay. Your beneficiary designations are a great tool for avoiding probate after you die. But who's going to handle your bills if you can't afford to do that for yourself you're not able to do that for yourself during your lifetime? How are they going to access your accounts to maintain your quality of life, right? So we need to make sure that we've got assets titled to the trust, that we've got an up-to-date financial power of attorney. Don't put off making changes, because if you become incapacitated, you'll no longer be able to update your documents. And by not having powers of attorney, you can end up with guardianships in the medical realm and conservatorships for the financial realm, okay? I had a case a few years ago where husband and wife, they've been married for 30 plus years. They hadn't updated their documents in about 12 years. Wife was incapacitated. She needed to go into a facility for 24/7 care. And husband was just shy of paying all the bills with his income and her income and everything he had access to. He needed to access her retirement account to pull out a couple extra $100 a month to cover those expenses. He went to the retirement account company with his power of attorney that he had for his wife, and they decided that because the document was 13 years old, they weren't going to accept it. Now, generally, their philosophy is that there could be something more current out there, and so they don't want to give your money to somebody else under inappropriate documents or old documents or documents that have been replaced. When you look at those types of situations, you think, who was she going to name other than her husband of, however many years? But they refused to accept it. We went to court. We got him appointed as the conservator. He was appointed as conservator. As being court-appointed conservator, you have to submit an inventory of her assets. You have to potentially do a bond, which is like an insurance policy that says that you won't run off with the money, but that's an additional expense. You have to provide an initial budget and a copy of her credit report. And then each year, you have to provide an annual accounting of how her money was spent. If it was off track from the budget that you submitted, you need to submit an amended budget or explain why it was off track. And you submit a new budget each year, and you do a new accounting each year. So there's additional ongoing costs with the court for doing a conservatorship that is not needed when we've got a financial power of attorney in place. When she finally passed away, and he was a conservator for probably about 5 years of us having to go in and do these. When she passed away, we have to do a final accounting. We have to get permission from the court of where we're going to distribute the remaining assets to, those types of things. So those are just all additional unnecessary expenses that all would have been avoided had the bank accepted her power of attorney. They didn't accept it because she hadn't updated it prior to her incapacity. So make sure that you are reviewing those things, you are updating them regularly, and you're making sure that you have what you need, okay? I also believe in education. So we do a graduating high school senior event to help them get their healthcare power of attorney and a HIPAA authorization. So as they're going off to college, parents can, have the authority to talk to doctors, get medical information, especially in emergency situations, and make medical decisions when the kids can't make them for themselves, right? I certainly know that after my kids turned 18, they were still looking to me to make doctor's appointments and pay medical bills and do some of those things. So having that healthcare power of attorney and HIPAA authorization is really important, As people get to about their mid-20s to mid-30s, I would encourage them to add a financial power of attorney. If they're purchasing a home, you might consider a trust. If you have children at those ages, consider documents naming guardians for them. From about 35 to 55, you definitely are going to want more of a complete estate plan and make sure that you've got all those things in place. It really is less about the amount that you have in assets and more about having the things in place that are going to minimize interruptions and allow the people that you trust to make decisions for you, both medically and financially, in the event that you can't do it for yourself, okay? Over the age of 55, you're going to want to make sure that you're confirming that your assets are not going to go to probate, and make sure your documents are fresh, You definitely, if you're still in the 35 to 55 year range, you might want to be considering if your parents' documents are in place to make it easier for you to help them if they become incapacitated, So you want to be, you're kind of at the in-between stage of like, are my children set up with the stuff that I need from them? Are my parents set up with the stuff that I need for them? And is everybody else set up with the information that they might need for me? And so, having those documents in place at the different levels, part of the reason that we started the high school graduation or the graduating seniors workshop for the healthcare documents is probably almost 8 or 9 years ago now. Francisco got a call on a Thursday afternoon, and a lady was calling saying her nephew was in the hospital. He was in this bad accident. He was in a coma. And because he was over the age of 18 and didn't have any documentation in place, the hospital put together a committee to make a decision on whether or not they were going to terminate the life-sustaining life support that he was on. They were not going to allow mom to make that decision because she wasn't authorized. And so they needed to go to court to get a guardian appointed, ask the court to appoint mom as the guardian. He worked that night to prepare the documentation. He went in on Friday morning for an emergency hearing. By about noon, he says there's about 6 attorneys there because he's there on behalf of mom and the aunt. The court appoints somebody for the ward. So for the boy who was in a coma, they appointed somebody. They also typically in those situations will appoint what they call a guardian ad litem, which is another attorney. The attorney for the ward is there to advocate for what the ward wants, right? The ward in this situation doesn't have the ability to communicate that because he's unconscious. So a guardian ad litem is somebody who is there to speak on the best interest of the ward. So what would be in the best interest of this person? And then the hospital had a couple of attorneys there. So the court does a hearing, hears from everybody, goes ahead and appoints mom as his guardian and allows her to make medical decisions. So the hospital says, okay, fine, we won't pull the plug on Saturday as we had planned. And, you can make the decisions. And she was like, well, one of my decisions is that I'm moving him out of this hospital because I really don't trust your judgment as a medical staff. And the fact that you are willing to pull the plug just doesn't make me happy. So I'm moving him. So she moved him over the weekend to a new location. And on Tuesday, the aunt called the office to tell us that he woke up out of the coma. So we were very fortunate that we were able to get this guardianship in place and that she was able to make those medical decisions for him. And, you hate to think of what the alternative was going to be. Now she's still guardian. All these years later, we file an annual guardian report with her for him because he still continues to need a guardian, but he's still alive. And whether or not he would have survived it had they, taken him off of life support, we don't know. But it's really important to have this documentation in place. And it's not like it was maybe back in the 70s where they just told you everything. The hospitals, the medical staff have been sued too many times for giving information to people that they shouldn't have. That in most cases, you can really have a hard time with the medical staff not giving you information unless you've got the right documentation in place. Here in Arizona, the Healthcare Directives Registry allows us to upload the healthcare documents to their registry. The hospitals have access to that, but in addition, they will give you a wallet card that has a QR code on it. So anybody who scans the QR code will be able to pull up your documents directly and see who your agents are. And that's been really helpful. I've had clients that have come in to say that, their spouse was having some kind of medical episode where they could not communicate. And the hospital staff, even though they walked in together, was not going to give the spouse the information that they needed. And luckily they had this registry and were able to pull up the documents. Nobody was having to run home during a really tough time to go get the documentation. They were able to pull it up and have it immediately. So I definitely encourage people to go ahead and have your documents uploaded with the Healthcare Directives Registry so that those are always available. Most healthcare documents, you can also use copies of them. You don't have to have the original. So in addition to the Healthcare Directives Registry, feel free to scan it and then email it to yourself or your family so that if somebody needed to pull it, they perhaps could just check the emails for that. Okay. So those are the important things that I really want you guys to know about. I've got some time for questions. I tried to set aside a little time here at the end for questions. So if anybody has questions, I think there's a chat box. Maybe not. Let me see. There it is. In call messages, it looks like there's a little, on my screen, there's a little box to the far right on the bottom where we can open it up. Let me see. The messages here, please. And so if anybody has any questions or anything that they want, we record these. We recorded some of our other presentations, and we'll be recording our future presentations, and those are on our YouTube channel. So I've put the link there. Alexis will be putting in the link for our upcoming, our next webinar. And Alexis, maybe you can remind us what that one is.
Yeah, of course, Michelle. So the next one is for the next, let me just confirm here. That is going to be November 7th, and that's hosted by Carmi Gutman, our financial planner here at Lifestyle Planning. And the topic is going to be long-term care. It's not just for old people. So he has a couple of pointers for people just to know that, plan ahead for this and not just wait until you actually need it to, go and get long-term care insurance. So great webinar coming up with Carmi. That's going to be next week. And then the one after that is hosted by Francisco. That's going to be the 18th of November. And that's going to be more over to the financial side as well. It's called You're Already Paying 1%, but Are You Getting Full Value for It? Which is more for people that are looking to know a little bit more about who they're working with currently with their financial planner. Are they actually getting all the benefits they could get from a financial planner, of course, right? And if that's something you guys are interested in, I'll definitely just drop that in here in the chat. And 1 second here.
Thank you so much, Alexis.
Yeah.
So let's see, Rachel, if we have powers of attorney, do we just write update in the new date so it's not considered old? I would be hesitant to confirm that that would be sufficient. More than likely what you need to do is just sign a brand new power of attorney with current dates on them. Okay, that's the best way to go, because your financial power of attorney especially should be witnessed by a third-party witness, and it is notarized. So by just writing update or signing your name, you're not complying with those two other requirements of having the witness and having the notary. So it's better to just sign a brand new one in the presence of a third-party witness and with a notary. Okay, good question though. I know people are often like, I just want to keep it simple and do it as easily as I can, but you want to make sure that you are doing it accurately so that it doesn't become something that we go to court to say, this was her intention and it looks like she was trying to update it and please accept it as that. And then the court's having to decide what it truly means and if it's truly effective. Okay. Anyone else with questions? I really appreciate you guys joining me today. We've really enjoyed being able to help get some of this educational information out to our community. We're firm believers in making our community stronger and providing them with good information, and that it shouldn't just all be kept at the attorney level. So hopefully this helped you. I know it was a lot of information, a lot of different scenarios, and yours may be different. Feel free to give us a call to set up a consultation, and we'll be happy to walk through the specifics of your situation. But definitely just keep in mind some of these things that have happened to other people and make sure that they don't happen to you, because they're expensive and they're stressful for the family and they're not always the way that you intended them to go. So just make sure that it's going to go the way you want it to. Okay. Thank you so much for your time today. We're going to wrap it up if there's no other questions, and we hope to see you at a future event. Have a great and safe Halloween.